Okay, our last case today is Wilcox versus State of Florida and Wilcox versus Secretary Department of Corrections, numbers 2023-1498 and 2024-0785. Whenever you're ready.
Good morning. May it please the court. I'm Bree Lacey, and I represent the petitioner, Darious Wilcox. I'd like to focus the argument on Claim 1 concerning the ineffective assistance of counsel at penalty phase. However, in the rare chance that I have additional time, I will address Claim 2 concerning the Hearst error. 6 attorneys worked on Mr. Wilcox's case in the first 9 months following his arrest. None did any work. Mr. Wilcox sat languishing in jail without any discovery and any information. And at one point, he told the court he wasn't even completely aware of the charges he faced. Feeling as he had no other option, he began filing his own discovery motions, his own Brady motions, and then he exercised his constitutional right to represent himself. Following the guilt phase, he then exercised his constitutional right for penalty phase counsel. The court at that time reappointed the RCC, or the conflict office, that was previously on Mr. Wilcox's case, and appointed Joseph Walsh. Now, Joseph Walsh wasn't a new player here. He had been on the case in the weeks leading up to the court's granting of Mr. Wilcox's motion to proceed pro se. However, at the time, Mr. Walsh was a second chair attorney who was working under Mr. Gershman, who had substantial capital experience. But come March of 2008, when he's appointed as penalty phase counsel, he's now lead counsel. He has no benefit of co-counsel, he has no second chair, and at the time he's in solo practice and he's in the infancy of developing his own firm. Now, Mr. Walsh had 5 months to prepare for this mitigation phase. Now, it's difficult to conduct a mitigation investigation in 5 months, but it's not impossible, and it was required to be done here. Under established and controlling law, it is counsel's duty to conduct a thorough mitigation investigation, and his obligations are not set aside because he has less time.
Could you describe in detail, because the brief kind of gave generalities as to, can you tell me exactly what you think he should have done that would have been more?
Certainly. He spends in 5 months, right? He sees 5 witnesses himself over the course of 2 days, over a matter of hours. And in those witness interviews that he's having, he has one general group interview of family members. We know from prevailing norms under mitigation that that's not necessarily how we do things, especially when you're asking sensitive information. It takes time to develop relationships with witnesses. It takes time to develop that information. He doesn't come back and speak with any of those witnesses again.
Well, but again here, what did he miss? What? Now, I've looked at the mitigation that came in the penalty phase proceeding, and the evidence that came in post-conviction. And there's more, no question, but it's in the same general genre. I mean, and obviously he had a very difficult upbringing, very chaotic, dysfunctional, dreadful in every which way. But that comes through in what was presented at trial. Now, can it be, was it expanded on and what you came up with for post-conviction? Yes, I don't deny that. But it's not materially different, or it does not materially, it seems to me, does not materially go beyond what they put in at trial. And so I'm just, obviously counsel can always do more. They can always do more. They can always bring more witnesses. But at some point there, you've got to make choices about how you're going to focus things. I'm just struggling to see how this is either deficient or prejudicial.
I have several answers for that.
I thought you would.
First, the jury did not hear substantial evidence. They heard from Mr. Wilcox's mother, LaWanda Wilcox, who presented about 23 pages or so of testimony, mostly about her own struggles. But because she was his primary abuser and someone who wasn't in the home where he lived, they didn't have context of him. The jury never heard what actually was happening in the home. They were led to believe that he was under the care and the protection in some shelter from grandma. And sure, some of that was provided, but they never heard the horrific facts of what was actually happening in that home. And so the jury was misled about the evidence that they actually received. Moreover, they never heard any mental health mitigation, right? They never heard any details about the neighborhood he grew up in and what his experience was. They never heard that as a child, he heard gunshots on an almost everyday basis, and he walked over dead bodies in his neighborhood of people he knew. They never heard that at 15 years old and 100 pounds, he went to an adult prison during his formative years while other children are preparing for prom and learning how to drive. That wasn't Mr. Darious Wilcox's experience. They never heard this really critical information. When a jury is asked to make the determination of whether someone lives or dies, they need a particularized picture. And this court has said, and the U.S. Supreme Court has said, that sometimes the subject matter does overlap. But that does not necessarily mean that additional information is not needed. And here, the jury didn't hear this information. They heard very minimal. And so the additional information that should have happened is counsel should have presented more information about his life, more context to that prior aggravator that he had, more mental health investigation. But the problem there is because of his inexperience and the lack of guidance he had, he completely failed when it came to the mental health mitigation. And this court has held that his actions surrounding how he handled that mental health mitigation is deficient.
Did he have an expert?
Yes.
And did he rely on the expert?
Yes.
And have we ever held that it is ineffective to rely on an expert, and we will find that ineffective or deficient later?
You have held in Miller v. State that how a trial counsel relies on an expert or how they handle the information that they're relying on can be deficient. And that is, in this case, knowing that having an ASPD finding was not going to be helpful, he still turned that report over to the state. The layers of the mental health handling are deficient in every way you look at it. It's certainly not a per se rule this court has that if you hire an expert and you rely on that expert, then you're completely obviated of any responsibility here or any fault. First, he hires a general expert, okay, even if we excuse that, which I don't concede that that's appropriate. He gets a report with just screening measures and personality testing. Not only does that report have internal inconsistencies that don't support her findings, and even if you forgive him for not understanding that, which I don't concede you should, this expert determined that there were cognitive deficits. Any reasonable attorney would have known in that moment that another expert was required. Additional testing is required because we know that a capital defendant is entitled to a full professional mental health evaluation, which did not occur here. Also, we cannot just alleviate trial counsel's obligation and say, well, this is an expert and he relied on this expert. We also have to remember trial counsel has to present this information to a jury, right? Had he had chosen to put this expert on the stand, he has to understand that expert's methodologies and findings in a way that that expert is able to educate the jury, right? So he would have learned then about the internal inconsistencies and he would have learned more about these findings. But what happened is he waits 4 months.
So what were the internal inconsistencies?
The internal inconsistencies are she uses a screening measure in which she determines that he has no significant psychopathy, which is a measure that is often utilized and relied upon in an ASPD finding. And then several pages later, without going through all of the individual requirements for ASPD, determines he meets the criteria. Also, in some of that analysis, she relies on her assumptions of a conduct disorder she believes he could have had without school records, without talking to any collateral witnesses in the case. But what you have is an inexperienced attorney who waited 4 of the 5 months he had to even send a mental health expert into the jail to meet with him. He gets a report and he has no time. But then his inexperience is even more compounded when he fails to tell the court he needs time. He fails to actually tell the court what's going on. He's got a board certification exam earlier that summer, which clearly mattered to him because he didn't speak to a single witness until after that exam. He's juggling another capital case, juggling a brand new firm, and he's also received very concerning medical news, which require additional medical appointments. He does not have the time or the experience to understand his own failures here and what he's done wrong. And we know from an email on the record that he knew mental health mitigation should have been presented to that jury when he reaches out to the RCC director and asks for additional funding. And in that email, he says, I have to present more than the mother. And he thinks that he can convince the judge to change the mind of the jury, which, by the way, in this case, 7 jurors voted for death. 5 voted for life here. The prejudice is clear. Just one single juror needed to change their mind. They were instructed on 4 aggravators and received 20 pages of mom's testimony, and still they voted only 7-5. This is not the most aggravated and least mitigated case. Mr. Darious Wilcox was entitled to a fair and reliable sentence. He got neither. Not only is Porter instructive here on the law as to what was not done, Porter is also instructive on the facts. Mr. Porter, tried in 1987, also represented himself at guilt. And less than 2 months later, he went to penalty phase, having then elected for representation. And his lawyer also only presented the testimony of a single witness. His entire mitigation story also spanned just over 20 pages. No mental health information was presented to the jury. The circuit court in post-conviction determined that there was no IAC, and this court upheld that. However, the United States Supreme Court reversed, finding that all of the additional mitigation that was presented could not be reduced to irrelevant. And you have the same errors in Porter that you have in Mr. Wilcox's case, but the errors are even more glaring. In Mr. Porter's case, he was difficult. He didn't want to meet with mental health experts. Mr. Wilcox was always participating with counsel. There was never a concern that he didn't want to participate. And in Mr. Porter's case, back when this court and our state had a 7-5 jury requirement to get death, Mr. Porter's jury voted 12-0. Mr. Wilcox's jury voted 7-5. The prejudice here is clear. However, the lower court failed in not even engaging with the mitigation, doing the exact same thing that the Porter court did. Instead, the court misapplied the Strickland standard and determined that counsel performed excellently. I'm not sure what we can glean as excellent for waiting 4 months to send a mental health expert in a capital trial in to see the defendant. He treated this case as an afterthought. Penalty phase was an afterthought to him. It was not the integral part of a capital trial that this court has held in State v. Lewis, which is required. And I do realize I'm in a bit to my rebuttal time. If the court has no further questions, I will wait until rebuttal.
Thank you.
Lisa Marie Lerner again with the Attorney General's Office. Your Honors, Mr. Walsh prepared an excellent mitigation case and did a lot of work. Both he and his mitigation expert testified at the evidentiary hearing that they put a ton of work into this case. In fact, between Mr. Walsh and his mitigation expert, they gathered all of the records that existed on Mr. Wilcox. So, in fact, my opponent here is extremely diligent, and even she could not find more documentation than what Mr. Walsh found. Additionally, he discussed Dr. Rappa's diagnosis and what she could testify to with Mr. Wilcox, and together they made a strategic decision to waive mental health mitigation presentation to the jury. The court held an in-camera hearing where Wilcox himself waived the presentation of the mental health mitigation.
Connected with that, could you address counsel's argument that the expert's report, I guess Rappa, that report was essentially incoherent? That somebody reading it could say, this just doesn't make sense. That this is, one part says one thing, and another part says something that is not consistent with what the other part said.
The state disagrees. The report is not incoherent. Mr. Wilcox's post-conviction experts disagreed with her findings that he had antisocial personality disorder, but that his conduct and his behavior that Dr. Rappa listed in her report, being arrested before the age of 15 numerous times, some of his other answers did support a finding of antisocial personality disorder, as did the fact of his continued law breaking by drug dealing and then this case itself. Additionally, counsel, after the jury came back with a 7-5 recommendation, did get another expert, another psychologist, who testified at the Spencer hearing for the court and essentially went through all of the same information that was presented post-conviction about the neighborhood and the risk factors and the cumulative trauma that Wilcox experienced by living in this neighborhood and living in that very crowded and chaotic household.
So how do you respond to the argument that, at least as to that additional information that came in at the Spencer hearing, that the jury, there was really no strategic reason not to present that to the jury?
Except that he hadn't hired Dr. Fischera yet.
Well, okay. Well, is that problematic, though? I mean,
no, it is not, because what you have is an attorney who has a few months to prepare a mitigation case. He does interview the witnesses. In fact, 2 of the witnesses he interviewed were 2 of the witnesses that testified at the post-conviction hearing. So he talked to them. He knew what they had to say, and that he had the information that they presented at the post-conviction. He also hired Dr. Rappa and talked to her, gave her the records that they had gathered, his whatever school and mental health and whatever records they could find. I remember that they could not find very many school records, but they got all the other records and gave it to Dr. Rappa. Once she wrote her report, it was at that point jury trial is facing, and he can rely on his expert. He's under no obligation, if she gives him a bad report, to go and hire other experts hoping to get a better report. If that were the standard, then we would have defense counsel serially hiring experts trying to get one that gives them something that they want, and that's not the standard. And so, based on Dr. Rappa's report, Mr. Walsh and Wilcox waived mental health mitigation evidence to the jury. And after that, Mr. Walsh was so concerned that he went out and fought with his office to get more funding, hired Dr. Fischera in hopes of convincing the judge, based on the 7-5 recommendation, to sentence Mr. Wilcox to life. And that's why he hired Dr. Fischera at that point, because he was still working diligently on the mitigation. As to the other issues, the state maintains that the post-conviction court did make appropriate credibility findings, which were supported by the record, and correctly denied the other claims. If there are no other questions, I will rest on my brief.
Thank you.
Thank you. I do have a brief items to address. Yes.
All seem to one instance. Four. One case, the argument was that he should have argued the voluntary intoxication defense. In the next case up, the argument was you should never argue that. That's the worst thing in the world. See, so like here. Or aggravators, counsel here was able to convince 5 jurors to recommend life, not go with death. So, I mean, it seems like he did some kind of a job to convince that many jurors not to recommend death.
Imagine if he had actually presented the information he had discovered.
Who knows? But he got 5 of them, and that's a feast in the case of this magnitude with 4 heavy, weighty aggravators.
And I think that helps us understand the real risk of prejudice here. And that is, you had a jury that was instructed on 4 aggravators. They returned no findings, not one finding of fact, not as to the theory or guilt, not as to any aggravation. This court struck one of those aggravators on appeal, the avoid arrest aggravator, leaving 3 aggravators. We maintain, as we've established in our briefing, that we don't even know if the jury found any of those aggravators. They made no findings of fact to do so. And there are factual issues when it comes to those aggravators. And this is after presenting just a snippet of Mr. Wilcox's life. There was so much more information that trial counsel could have and should have presented. The standard isn't whether he did a great job or tried his best. The standard is, did he provide constitutionally effective representation? A lot of us can do our best and not be great. No matter how hard I try, I am a terrible basketball player. He was entitled to constitutionally effective representation, which he did not get. Counsel had 5 full months to prepare. And as you look at the numbers in this case, I'm a big numbers person. The mitigation specialist spent less than 37 substantive hours on this case, much of which was report writing, in which she took the 3 reports that she had written about interviews and she put into a larger report. There was not a lot of work in doing our best here. Trial counsel testified at the evidentiary hearing that didn't have a lot of time and he was pressed. And I believe the mitigation specialist testified that they could have done a better job, and they could have. I'd also like to state that I know that the state has mentioned that he gathered records. He didn't use the records. He didn't use information gathered in those records. Certainly didn't hire an expert to discuss the possible brain damage that Mr. Wilcox may have experienced having been in solitary confinement. And while Mr. Wilcox may have waived the presentation of mental health mitigation at the direction of his trial counsel, that was after the morning when trial counsel turned over that report to the state, and then the state stood up during the waiver and said, he's got an access to finding of ASPD. He just waived that mental health mitigation, but the state informed the court that that ASPD finding was there. There was no strategy decision to wait for Dr. Fischera until after penalty phase. His inexperience meant that he didn't do proper investigation and vetting of experts to hire an appropriate expert here. He didn't know how to figure out whether the report lent any use to him. He didn't follow up with his expert. He didn't do the full mental health evaluation that was required. He panicked, and then he hires another expert. And then he gives that first report to the second expert. So now the state is able to ask questions about that first expert that Mr. Wilcox waived the presentation of, without that expert having to sit there and undergo cross-examination for her own errors. And so now the state and the court is hearing this information untested. The jury never heard the information necessary here. They never heard a complete story about Mr. Wilcox's life, and they certainly didn't hear any information post his time in prison and in the years leading up to the instant arrest. That information was presented in post-conviction. I also want to make the point that while Dr. Fischera may have been more on point and offered that information to the court about the adverse childhood experiences, again, the jury never heard that information, never heard the compelling impact that adverse childhood experiences would have on a child's brain. And Mr. Fischera, as we've argued in the briefing, was not fully prepared. An experienced and reasonable attorney would have known that an ASPD finding, particularly in light of this report, was not the end, but it was the beginning. We ask that you remedy the constitutional error here and that you reverse the finding and grant Mr. Wilcox penalty phase relief. Thank you.
Thank you. We're adjourned.